Hello everyone, welcome back to the video lecture series on paper number 5, CMA Inter, Business Law and Ethics. Previously, we have been discussing on various chapters from an examination point of view. We were discussing the most important topics in each chapter in brief span of time. Today, we will be covering Limited Liability Partnership Act 2008. A limited liability partnership is another form of doing business in India under LLP Act. The benefit of this business form is that it has a feature of limited liability and can be seen in which is seen in companies. Despite being a partnership, there are many features that an LLP has which are like that of a company. This business form can continue its existence irrespective of changes in partner, much like a company where membership change in hands. So, what is an LLP? That otherwise limited liability partnership. It is a hybrid of company and partnership. The benefit of a company is that it is a separate legal entity. The benefit of a partnership is it is much simpler form compared to a form company. The liability of a partner is unlimited in case of a partnership, whereas it is limited in case of a company. So, considering all this, a entity called LLP, Limited Liability Partnership, which has the benefit of separate legal entity, limited liability, and so on, is there. So let us discuss the concept of LLP. It is an alternate corporate business form that gives the benefit of limited liability of a company and the flexibility of a partnership. It can continue its existence irrespective of changes in partners. It is capable of entering into contracts and holding property in its own name. It is a separate legal entity and is liable to the full extent of its assets, but liability of partners is limited to their agreed contribution in an LLP. No partner is liable on account of the independent and unauthorized actions of other partner. Thus, individual partners are shielded from the joint liability created by other partners' wrong business decision or misconduct. Mutual rights and duties of partners within a LLP are governed by an agreement between partners or between the partners and LLP as the case may be. These are the features of an LLP. So in India, LLP is governed by Limited Liability Partnership Act 2008. So while studying this chapter, you can see it is a long chapter. It will be covering a lot of area. From an examination point of view, some concepts are repeatedly asked. And also, there is a lot of procedure, conversion, merger, shifting of registered office, and their long procedures have been detailedly mentioned. Considering the examination, previous examination, we'll be covering few points or few concepts which are relevant or repeatedly asked. The concept which are not covered, students are requested to cover and get back if there is any doubt. Who may be a partner in LLP? Any individual or a body corporate can be a partner of LLP. So that means a company can be a partner in an LLP. Body corporate is defined under Section 2, Subsection 1, Clause D of the Act as a company is as defined in Section 3 of Companies Act 1956. Includes limited liability partnership registered under the Act, limited liability partnership incorporated outside India, company incorporated outside India, but does not include a corporation sold, so cooperative society, any other body corporate not being a company, LLP or a central government may, by notification or in official gazette, specify. An individual shall not become a partner of an LLP if he has been found to be unsound mind by a court, He is undischarged insolvent. He has applied to the adjudicate as insolvent. So in these cases, a partner cannot be admitted as a person cannot be admitted as a partner. So what are the minimum number of members to be in an LLP? There should be at least two partners. Who is a designated partner? Provides every LLP shall at least have two designated partners. The designated partners shall be individual, at least one of them shall be a resident of India who has stayed in India for a period not less than 182 days during the preceding 1 year. In case all partners of an LLP are body corporates or one of more of the partners are individual or body corporate, then at least two individuals or a nominee of body corporate shall act as designated partners. If incorporation documents specify who are the designated partner, such person shall be designated partner on incorporation. If the incorporation document states that each of the partner from time to time of LLP is to be designated partner, every partner shall be designated partner. Any partner may become or cease to be a designated partner in accordance with LLP agreement. If you take a company, you know, a person who put the money is called a shareholder, and the person who run the company is called directors, collectively called board of directors. In the case of an LLP, the person who put the money is a partner. The person who run the company is a designated partner. There shall be at least two designated partner in a LLP. What happens if two shareholders are a company who shall be designated partner? So the two company shall nominate each person as a designated partner. Filing requirement. An individual shall give his consent to become a designated partner in Form 9. The particulars of an individual who has given his consent to act as designated partner shall file Form 4. The individual who has given consent to act as partner or a designated partner shall file Form 2. So these are all procedural aspects of LLP in daily life. If you have an appointment or resignation of the partners, you will be required to file with registrar of companies, otherwise Ministry of Corporate Affairs. So these are all the types of forms and formalities to be complied. Disqualifications to become a designated partner. Rule 9 prescribes that a person shall not be capable of being appointed as a designated partner of an LLP if he has at any time within the preceding 5 years has been adjudged insolvent, suspends or has at any time within the preceding 5 years suspended payment to the creditors and has not in any time within the preceding 5 years made a composition with them, has been convicted by a court for any offence involving moral turpitude and sentenced in respect thereof to imprisonment for not less than 6 months, has been convicted by a court for an offence involved under Section 30 of the Act. So, as per LLP Act, a person is adjudged insolvent, convicted for an imprisonment more than 6 months, conducted any crime under Section 30, etc., are disqualified from being a designated partner. What are the liabilities of a designated partner? Responsibility for doing of all act matter things as required to be done by the LLP in respect of compliance of provisions of the Act, including filing of any document, return, statement, report under this Act, as specified in the agreement. Liable to all penalties imposed on the LLP for any contravention of the provisions. So let us discuss the incorporation procedure of an LLP. So what are the different steps for incorporation of an LLP? First, there is reservation of name. Then there is submission of incorporation document with the registrar. Then registration of LLP. These are the three steps of formation of an LLP. As far as an reservation of name is concerned, LLP form number 1 by paying 200 rupee You will pay, you submit to the registrar. Once the application is submitted, registrar, if deemed fit, shall provide the name reserved for certain period. The name shall be available for reserved for a period of 3 months from the date of intimation by registrar. As you know, a company has a corporate identification number, otherwise SIN. In case of a company, it is LLPIN, that is Limited Liability Partnership Identification Number. The name with which the LLP, the application for this purpose shall state LLPIN of LLP or SIN of company or registration number of other entity as the case may be. The name with which LLP or other company or any other ground was incorporated, grounds of object to the name of LLP. These are the requirements for reservation of name. Next, submission of incorporation documents. The incorporation document shall state the name of the LLP, state the proposed business of LLP, state the address of the registered office of LLP, state the name and address of each of the persons who are partners of LLP on incorporation, state the name and address of persons who are designated partners of LLP, contain such other information as may be prescribed. What is the fees for registration of LLP? Up to 1 lakh, it is 500. 1 lakh to 5 lakh, 2000. 5 lakh to 10 lakh, 4,000. 10 lakh above, 5,000. As you know, company has capital, LLP has contribution. So once you have submitted, you will get a registration certificate or certificate of incorporation. So what is the effect of a registration of LLP? On registration, an LLP by name become capable of suing or being sued, acquire, owing, holding, developing, or disposing of property, whether now movable or immovable, tangible or intangible, having a common seal, doing and suffering such other acts, things as body corporates may lawfully do and suffer. These are all the capabilities once you have LLP incorporated. A person shall cease to be a partner of LLP on following ground: on death, on becoming unsound mind, on adjudicating as insolvent. From a compliance point of view, every year an LLP has to file Form 8 and Form 11. Form 8 is statement of accounts of solvency. It has to be filed within 30 days of end of 6 months of financial year, that is within 30 days of September 30th. If a LLP has closed financial year on 31st March 2011, it shall file statement of accounts of solvency in Form 8 with registrar within 60 days from the date of end of 6 months. Sorry, it has to be filed within 60 days. Here it is mentioned 30 days. From the date of end of 6 months financial year to which statement of account and solvency relates. The statement of accounts and solvency of LLP shall be signed on behalf of LLP by a designated partner. Each designated partner shall be taken to be a party to its approval unless he shows that he looks all reasonable steps to prevent their being approved and signed. So, when does audit of accounts become applicable for an LLP? If the turnover of an LLP does not exceed in any particular year 40 lakhs and contribution does not exceed 25, there is no need for the accounts to get audited. In other words, if your turnover exceed 40 lakhs or contribution exceed 25 lakhs, you are required to get books of accounts audited. Appointment of auditor. A chartered accountant in practice is a qualified for appointment as auditor. The auditor shall be appointed for each financial year of LLP for auditing its account. The designated partner may appoint an auditor at any time first financial year before the end of the first financial year, at least 30 days prior to the end of each financial year, to fill casual vacancy in office of auditor in case when the turnover or contribution of LLP exceed the limit, to fill up the casual vacancy or vacancy caused by removal of auditor. So I told you you have to file Form 8 with the registrar of companies. Similarly, you have to file Form 11. That is a form. That is a annual return. Annual return of LLP having turnover up to 5 crore during the corresponding financial year and contribution up to 50 lakh shall be accompanied with a certificate from a designated partner and any other signatory to the annual return to the effect that annual return contains true and correct confirmation in all other cases. The annual return shall be complied accompanied with a certificate from a company secretary in practice to the effect that he has verified the particulars of the books of records of the LLP and found them to be true and correct. So every company LLP has to file Form 11 if the turnover is up to 50 lakh, sorry, 5 lakh, 5 crore and contribution up to 50 lakh. There is no need for any certificate from a company secretary. Whereas if your turnover is more than 5 crore and contribution exceed 50 lakhs, you are required to get a certificate from a practicing company secretary. So if you are aware of Companies Act, likewise, similar provisions exist in LLP. So there is conversion of firm to LLP, conversion of private limited company to LLP, conversion of unlisted company to LLP. Here and all, a lot of procedural aspects are involved. So students can go through that. We'll be briefly going through this. As far as examination is concerned, previously we could see shifting of registered office from one state or local area. You could see asked in question paper, but it is highly likely that a question can come from here also. So first is conversion of firm to LLP. A firm may apply for registrar by filing the statement of all partners in Form 17, name and registration number, date on which firm was registered, incorporation document and statement. On receipt of above document, registrar shall register the document, issue a certificate under Form 19. Registrar may determine the stating that the LLP is on and from the date specified in the certificate registered under the Act. The registrar may require the documents to be verified in such manner as he consider fit. The LLP shall, within 15 days of the date of registration, inform the concerned registrar of firms with which it is registered under the provisions of Indian Partnership Act about the conversion and particulars of LLP. A company may apply for convert itself into an LLP only if there is no security interest in assets subsisting or force at time of application. The partners of LLP to which it converts comprise all shareholders of company and no one else. Company has to apply with registrar by filing the following document: a statement by all its shareholders in Form 19 and fees containing following particulars: the name of the registration number of company, date on which the company was incorporated. The less on receipt of above document, registrar shall register the documents, submit to provisions of the Act and rules made thereunder. The registrar may require the documents to be verified as he considers fit. The registrar shall issue a certificate registering in Form 19 as the registrar may determine, stating that the LLP is on and from the date specified in the certificate. The LLP shall inform the concerned registrar of companies within 15 days of the date of registration about the conversion and of particulars of LLP in form along with fees. If the registrar is not satisfied with the particulars or any other information furnished to the registrar may refuse to register. Against the order, appeal may be made before the tribunal. Next, conversion of unlisted public company into LLP. A company may apply to convert into LLP only if there is no security interest in its assets and subsisting or force at any time of application. The partners of LLP to which it converts comprise all the shareholders of the company and no one else. Company is also to file following documents: statement by all its shareholders in Form 18 with following particulars: the name and registration number of the company, the date of which the company was incorporated, incorporation document and statement. Like above, same procedure. Effect of registration. On registration of conversion from a partnership firm to LLP, a private limited company into an LLP and an unlisted company into an LLP, following will be the effects. There shall be LLP by the name specified in the certificate of registration registered under the Act. All tangible and intangible property vested in the company, all assets, interests, rights, privileges, liabilities, obligations relating to the company and the whole of the undertaking of the company shall be transferred to and shall vest in the LLP without further assurance, act, or deed, and the partnership firm or a private limited company, unlisted public company, shall be deemed to be dissolved and removed from the records of the registrar of firms or registrar of companies. Let's understand the concept of foreign company, foreign LLP. The term foreign LLP is defined under Section 2, Clause M of Act as LLP formed, informed, or registered outside India, which establishes a place of business within India. Rule 34, subsection Subrule 1 provides foreign LLP shall file with registrar in Form 27 with 30 days of establishment of placement place of business in India, a corporation which include a copy of certificate of incorporation, registration document defining the constitution of LLP, the full address of registered and principal office of LLP in the country of incorporation, the full address of LLP in India, which is to be deemed and as its principal place of business in India, list of partners and designated partners, if any, and the name and address of two or more persons residing in India authorized to accept on behalf of the LLP service of process any notices or other documents required to be served on the LLP. So these are all procedural document aspects. You can go through that. So if you're aware of Companies Act, Section 230 to 239 is dealing with compromise arrangement. Likewise, which means a merger, demerger concepts. Likewise, in LLP Act also, you can see compromise and arrangement. The following may apply before tribunal for compromise or rearrangement: the LLP, creditor of LLP, partner of LLP, in case of LLP which is being wound up, the liquidator. So if you're a little bit having aware of what is the concept of merger, there will be a meeting of creditors, shareholders. If you are going to have a meeting, you should give 21 clear days notice. You need to file certain forms. You need to give advertisement. Likewise, these are all different kind concepts. You can just go through this. Strike off of LLP. In Companies Act, there is Section 248, strike off of company. Likewise, you can see in LLP, where an LLP is not carrying on any business of operation for a period of 2 years or more, the registrar has reasonable cause to believe the same suo moto action for striking off the name of the LLP can be taken. So, if there is no business operation for more than 2 years, the registrar has the right to suo moto strike off the name of the LLP from the register. So, you can see some questions from this part of the chapter dissolution. What are the different modes of winding up? Voluntary winding up, compulsory winding up. All concept procedural aspects is discussed. Different forms, documents. You can go through that. Before the tribunal, you need to submit various documents, list of creditors, so and so. So, for a merger, you will appeal before NCLT, National Company Law Tribunal. If you are not satisfied with the order of NCLT, you can appeal against the order of NCLT before NCLAT, National Company Law Appellate Tribunal. Even here also, if you are not satisfied, you can go above, that is Supreme Court of India. That's all. Thank you for watching.